Hello guys, this is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode, we are talking about the part 3. You should know that today's episode is the part 3 of how to identify equitable interest, particularly purchase of land in relation to the Nigerian context, that is the customary law. In part 1, we talked about what? This same topic, but in relation to the common or English law. If you have not watched the part 1 of this video, please make sure you do so, as well as the part 2. But in the part 2, we talked about the requirement under the customary law, and part 2 taught us 2 requirements. Part 1 said, when you have equitable interest, this is what you do. For you to have equitable interest, all you need is an agreement. Where there is an agreement, then you can have equitable interest. But where the other party has a legal interest, and not just that, does not have notice of the equitable interest, then the other party will prevail. But when we come to the part 2, where we talked about the case of Ogunbambi versus ABOWABA, he gave us 2 requirements. He said that number 1, there must have been what? There must have been a payment of money, which is evidenced by a purchase receipt. And once that has happened, what is the second thing we look at? We look at whether or not the person has been led into possession. Because the moment we can have payment of money, the moment we can show that the person has been led into possession, what remains? That has given what? That person a cloak of equitable interest, so much so that it's so potent against any bona fide purchaser of value. The reason it is potent is because that particular person has not only been led into possession, he now gives everybody notice because he's in possession. See, na me dey the land, nobody is to come and buy land when I dey here. That was what happened in the case of Oshinobi and Olowu, and also in the case of Ogunbambi versus ABOWABA, where the court held that, did you see that he was on the land? This is the purchaser now. He has a receipt to show that, there must have been an agreement, and then he's on the land. What else do you need? You have notice. But now, I told you in my last class that not only are you supposed to do both of them, the next thing that you are supposed to do, that next thing is what? There is a third requirement. And that third requirement was given in the case of Oransanmi versus Idowu. And that's what we are interrogating in our lecture today. But before we get into the crux of that, if this is your first time of coming to my channel, please make sure that you click the subscribe button and make sure that you click the notification bell, so that anytime I release a video of this nature, which is going to be of interest to you, you, my friend, will be one of the first set of people to watch that particular video. Don't forget to follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. Also, I would like to give a big shout out to Komolafe Praise, a University of Ilorin student who made sure that the note which we use in this class is possible by typing it. Also, I would like to say a big shout out to Odunwale Emmanuel, who helped with the media in relation to this particular class. So thank you very much, guys. We move straight into what we are talking about today, and that is the third requirement in relation to customary land transaction. Here we are talking about the equitable interest, the cloak of equitable interest. We know the first requirement is that there must have been what? There must have been purchase receipt. The second requirement is that not only must you have purchase receipt, you must have been led to possession. But what is the third requirement? Now let us now go to the third requirement and search for it. Oransanmi and Idowu. Now, you should note that Oransanmi and Idowu is a case in which the land sold was held by title under the general law and not under customary law. I have told you the difference in the last class. Now, in this case, the respondent bought a land in Lagos by a deed of conveyance. Now, we are saying that R bought a land by what? By a deed of conveyance. What comes to your head is what? Legal, Abi? And then traces his legal title back to an undisputed owner. So that means that, okay, we have a very solid case here. You have a legal interest because it was by what? Conveyancing. And then you can even trace your title in your conveyance to a person who is an undisputed owner. Now, 20 years before the sale by the respondent, the appellant had acquired an equitable interest in the land by paying for it, obtaining receipts, and going into possession. Now there is a problem. Ojati boxed. There is a problem right now. Now we are saying R bought a land by legal conveyancing. Not just that, he was able to trace his title back to somebody. What do you mean by trace title? In a legal conveyance document, that's a deed of assignment or something, there is something known as recital. Recital has every single person that has come in contact with that land before you. That's what they call tracing. So when you want to buy land, you go to the recital. You can see, Chief Ologbela has bought this land. Before Chief Ologbela bought it, Chief Kiniko bought it. Before that, Mr. Kiniko bought it. Before that, Mr. You can trace it, and he did his due diligence to make sure that he traced it. His due diligence. And he traced it. This is the person, this is the person, this is the person, and all that. Now, after he now bought the land, he now hear that somebody now said that, somebody said that what? I've done everything I'm supposed to do. Somebody now said that 20 years ago, that's the appellant in this case, bought land 20 years ago. When he bought it 20 years ago, he collected receipts. When he collected the receipt, he entered possession. Ogunbambi and ABOWABA told us that yes, those are the two requirements that are necessary. Collect receipts, my dear. Collect it. And do what? And enter possession. Do not forget that if it has been a legal conveyance, there would have been a document, yeah? If there had been a document, that means that he would have seen it. Who is the he here? R was the one who bought it and did his own legal kiniko, did the whole recital, traced this thing. But you know that A bought it through Equitable. It was not written, so there was no conveyance. So R did not even know that there's anything that has to do with A, because A's own is what? Is I pay you money, you give me receipt, I enter possession. Simple. No right. They didn't write his name anywhere. I pay you money, you give me receipt, I enter possession. Because according to Ogunbambi and ABOWABA, I pay you money, you give me receipt, I enter possession. That is the requirement that is necessary for equitable interest. So you can see the two conflicts. If you are relying on the case of Ogunbambi and ABOWABA, I mean, A is the one that has the whole this thing. Even though R has the whole of legal interest, A will still be ranked far above R. That's what the law says. However, there is a judge, Ademola, Justice of the Federation. He was the Chief Justice of the Federation at that point, and he was the one that gave a lead judgment in this case. What did he say? He said to rely on Ogunbambi versus ABOWABA, there must be a continuous and undisturbed possession in addition to payment for many years by the claimant or by his predecessor in title. And I've told you before, predecessor in title is someone who comes before you, whom he claims. Now, in other words, it was not enough that the appellant went into possession after the sale to him, but it is important that he remained in possession. Ademola CJF, you don't give us new requirement. Do you see that? Now, we started with one thing. There must have been what? Payment of money, and that would have been evidenced through a purchase receipt. But we are not stopping there. We went to number 2. He must have been put into possession. There are 2 authorities for that: Ogunbambi and ABOWABA, and Olowu and Oshinubi. But the justices of the Supreme Court, they said that is not enough. We need a number 3. It is problematic to have just those 2, because where a person, like in this case, now looks through the recital, he wouldn't see your name and you are no longer on the land. How will he know? There's no way he would know. So the court now said, you know what? Let us now put a 3rd requirement. What's our 3rd requirement? He must have continuous possession. Continuous possession. ORASANMI versus Idowu. Continuous possession. Not only are you supposed to be on the land, not only are you supposed to have receipt of payment, you must have continuous possession for you to have that equitable interest. That was given in the lead judgment of Ademola, Chief Justice of the Federation. Now, furthermore, the court upheld the trial court finding that the respondent had no notice of the appellant prior equitable interest when he bought the land, and so the respondent's legal interest prevailed. One inevitable consequence of the decision of ORASANMI v Idowu is that if the first informal purchaser does, as required, remain in continuous possession of the land, any subsequent purchaser must necessarily have constructive notice of the first purchaser's equitable interest because of the general rule stated earlier that a purchaser is deemed to have constructive notice of the interest of any person in possession of the land. Now, I think we need to understand Ademola in this case, and it's very understandable. In short, that is a fair judgment. In as much that it seems unfair to this other party because he didn't know that there need to be a requirement of continuous possession until Ademola JCA made that pronouncement. But that pronouncement was necessary. Why is it necessary? You see, when you are buying land, like I said, the respondent he had done his due diligence. He went to the land, there was nobody there. He got the document, the title. He didn't just sit down and say, let me cross my leg and drink cold zobo. No, he went again. He went to investigate the title. Okay, has this one done what he's supposed to do? Yes, he has done it. Has that? He then traced it to an undisputed owner, and then he said, yes, now I am rest assured that this land is mine. Now you now hear from nowhere after paying millions. You know, land is millions. So after you pay like 5 to 10 million or 50 million, you now hear that somebody somewhere paid money one time. In this case, 20 years ago. And there is receipt to show. But if there is receipt to show and you were led into possession, you were not staying in continuous possession well enough for me to know. Now, this law has given us something. It has triggered something that it did not expressly state. If you want to leave your house, if you know you did purchase receipt and enter property, if you want to leave your house, that means you don't want to stay there full time. Maybe you are moving from Ogun. The house that you bought was at Ogun. You are moving from Ogun to Lagos, or the house you bought was in the north. You are moving from north to the south or the east. You have to go and effect a legal conveyance first before you move, because as you are moving, your continuous possession has stopped, and therefore Oransanmi and Idowu's principle will stop on your head. What does it mean by it to stop? For you to continue to have an equitable interest on that land, Oransanmi and Idowu have said that you must have a continuous possession. But in this case, you have the first requirement, receipt. You have the second requirement, you entered possession. But now you want to leave that third requirement as stated in Oransanmi and Idowu, and you want to come to Lagos, or you want to go to another place. Then, by effect, if you want to continue remaining on that land, or if you want that land to continue being yours, you must go and effect a legal conveyance. Because if you don't effect a legal conveyance, that third requirement of continuous possession is taken away. Do you see that? It's taken away. And once it is taken away, any bona fide purchaser of value of that land without your notice, as in this case, the person did not have notice, would automatically be the owner of the land. Do you see that? You see that land law and equity is very sweet, very interesting. Because once you know the principle, you don't have a problem. The people who have problem with land law and equity are those who don't know the principle. Once you sabi principle, my guy, nobody can tell you rubbish. Do you understand that? So with that, we move to another topic when we are talking about how to identify equitable interest. We move to what is known as restrictive covenant. Restrictive covenant in our class on how to identify equitable interest. And that's what we'll be talking about in our next class. Thank you for watching to the end of this lecture. Please make sure that you share with your friends and any other person that you think will need the course. Also make sure that you like the video and subscribe. Don't forget to subscribe. Also follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. Thank you so much for watching. I will see you in my next class.